Good afternoon, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Want to talk to everybody today about service of process and the uniform implications throughout the jurisdictions. And I've been talking to everybody lately about the PMA stuff in regards to clarifying your foreign state status. And in those discussions, we talked about the service. And the service in all of these matters in regards to the state courts, your district courts, your United States courts, these are all commercial courts. Every last one of them is a commercial court. And the way we know this is because they assess fines, fees, and penalties. Okay? That means when they assess it as an outcome, that is their initial intent to begin with. Okay? So their initial intent is seeking economic substance by and through adjudication and assessment and application and enforcement of fines, fees, penalties, and such. So they're all civil matters, commercial matters, contractual matters. Those all mean the same things. Civil, contract, commerce. And as I've discussed before, the commerce is synonymous with traffic, transportation, and trade. That's why we see that contract is law. Everything is law. We even know that our state statutes are considered international law. Why? Because they're all commercial. They're all contractual. We also see this in the federal rules, federal acquisitions regulations, which is part of the Title 48 of the Code of Federal Regulations, Part 52.212-5, where it says contract terms and conditions to implement statutes or executive orders - commercial item. Okay? So when we talk about commencing a civil action, we look up commencing of a civil action, and we see that Title 2, Rule 3 to Rule 6 of the Federal Rules of Civil Procedure deal with commencement of civil suits. Okay? Here we're talking about a very simple statement that doesn't say deals with commencement of federal civil suits. It doesn't say commencement of state civil suits. It doesn't say commencement of public civil suits. It doesn't say commencement of private civil suits. It says deals with commencement of civil suits. That's uniform throughout all jurisdictions. Okay, that basic comment shows that it's uniform throughout all jurisdictions, and that civil suits means contract suits, means commercial suits, it means economic suits, it means financial suits, it means banking suits, it means tax suits, it means probate suits, it means will suits, it means testament suits, it means testator suits, it means whatever kind of suits when you sue someone, you're filing a suit against somebody in a civil action. When you warrant an accusation, you state a claim. Very distinct differences. And this is why I urge people to get back to the words. Language is everything. So as we keep reading, it says, a civil suit is commenced by filing a complaint with the court. With the court. Just like you file a claim with the court, you file a civil suit with the court, which is a complaint. Again, very distinct and different. And what you've done is you filed a complaint with the court saying that somewhere along the line, a contract has caused a detriment to yourself. So when the state, as a plaintiff, comes forth and files a civil suit, they have said that somebody has caused them, they have made a complaint that somebody has caused them detriment. That's an impossibility against a fictitious plaintiff. You cannot cause a fiction loss. You cannot cause a fiction detriment. Period. All these court cases are fraud. Unless a live man gets up there as plaintiff and is willing to prosecute himself through third-party counsel who has no right to speak other than to him and tell him what he should or should not say to the rest of the court. The counsel is not to be heard. The plaintiff is. He is to go forth and prosecute by bringing forth witnesses who will testify on the stand on his behalf. He cannot testify himself. He has to bring witnesses. Okay, so a civil suit is commenced by filing a complaint with the court. A claim is commenced by filing an accusation, meaning that you are blaming someone else, another live man, for the loss or harm or detriment that you are suffering by any actions, whether they be by a physical action or by a commercial action where they're executing as executor or administrating as administrator or ministering as minister of affairs that they have no right to do. That's a tort. That's a trespass. Executor daison tort. So, a civil suit is commenced by filing a complaint with the court. Rule 4 deals with service of summons. Rule 4 of the Federal Rules of Civil Procedure is directly concerning summons. And this is where we're talking about service. I was talking about service in regards to the Foreign Sovereign Immunities Act and Title 22 of the Code of Federal Regulations, wherein it prescribes that those diplomatic channels of service in sections 93.1 and 93.2. Now, this is uniform in both the Foreign Sovereign Immunities Act under Title 28 of the Code of Federal Regulations, Section 1602 through 1611, and the Code of Federal Regulations, Title 22, Sections 93.1 and 93.2. Here we're going to see Federal Rules of Civil Procedure. Again, it's going to be uniform. A summons must name the court and the parties. And this is where we talk about all parties must be identifiable and identified. And when we identify those parties, we have to identify them in their capacities as they are named on the instrument. Like I said, all these court actions are commercial actions. That's an instrument they're developing. It's a series of transactions. And each time you sign your name or a name to an instrument, you are signing as an authorized representative, giving an unambiguous authorized signature on a financial instrument that you have been duly authorized to do so. And through that authorization, you are not liable on the instrument for the person named in the instrument, period. And again, this is uniform throughout all jurisdictions. B, be directed to the defendant. There's an ambiguity here that exists because defendant can be clarified not to be yourself. The defendant is a person. And if you're going to direct it to a defendant, then you're not going to be directing it to me. So again, through diplomatic channels of notice, we have to comprehend the thing that they have to show proof and on and for the record that the defendant is a corporate person. This is one of the elements of identifiable and identified, and that I am the foreign state that has been authorized by the domestic state to give an unambiguous authorized signature, because they can't. Because as trustee, they are liable. They can't give an unauthorized signature saying that they're not liable, because they already hold the capacity and status of a state trustee that is liable. Comprehend this. C says state the name and address of the plaintiff's attorney, or if unrepresented, represented, of the plaintiff. D, state the time within which the defendant must appear and defend. And in Rule 4 in civil procedures, it gives a time for a response to appear and defend of 90 days. But if we remember, when we look back at Rule, what was it? Let's see here. Title 22 of the Code of Federal Regulations 93.1. When we go back and look at that, and this is where we're talking about the notice to a foreign state, and they have let's see here. It says something about 30 days, and I can't remember if it's 93.1 or 93.2, or maybe it's in 28. Maybe it's in 28 U.S. Code. We'll look here. Okay, in Title 1608 of the United States Code, or Title 28 of the United States Code, Section 1608 says service, time to answer. This is your Foreign Sovereign Immunities Act that I've been talking about. And in Part 4 of subsection A, it says, if service cannot be made within 30 days, under paragraph 3, by sending 2 copies of the summons and complaint and notice of suit, together with the translation of each into the official language of the foreign state by any form of mail requiring a signed receipt to be addressed and dispatched by the clerk of the court to the Secretary of State in Washington, District of Columbia, to the attention of the the Director of Special Consular Services. If it cannot be made, then the Secretary shall transmit 1 copy of the papers through diplomatic channels of the foreign state, and shall send to the clerk of court a certified copy of the diplomatic note indicating when the papers were transmitted. So there still is no actual requirement or enforcement, even through this notice of foreign state diplomatic channels, of acceptance. It's just stating that the diplomatic counselor has sent notice from that point on. But again, what is it? Do they have a certificate of that mailing where somebody's received that receipt or signed that receipt? No, they don't. So when we go back and we look at this rule number 4, says E, notify the defendant that a failure to appear and defend will result in a default judgment against the defendant for the relief demanded in the complaint. Now, in these civil filings, when they're processing these civil filings and they're asking for fines, fees, and penalties, along with jail time, anytime they access these or present that in a court case, that's a felony. That's treason. That's sedition. Sedition on behalf of the prosecution, and treason on behalf of the judge for even entertaining that idea. Period. Comprehend this stuff, people. They're claiming that they are going to suffer a detriment in the future. And they're claiming that detriment now by saying that you violated one of their supposed codes, and therefore they have to institute a commercial fine, fee, or penalty, and along with that penalty comes a jail time. Excuse me, nobody's caused any kind of another man to suffer detriment or harm by taking them out of their existence in their normal life. Taking away their life, liberty, and freedom. That is sedition on behalf of the prosecution, and as a public trustee, he is the public trustee, and therefore acting on behalf of the public. It makes you an enemy of the state, and makes the state and the rest of the general public an enemy against you in implication by the record. That's treason. It's called an act, is called mixed war upon the people. So then we go to F. It says, be signed by the clerk. Be signed by the clerk. Not stamped. Wet ink signature. Be signed by the clerk. And then it says, G. Bear the court's seal. Not a stamp, a seal, an impressed seal, embossed upon the paper. Now, I'm not going to read this whole thing, but we're going to put the rest. So we're going to put the rest of it to you guys to do the research. This is Federal Rules of Civil Procedure, Rule 4. And if you just look up Federal Rules of Civil Procedure, it'll give you the whole thing, and you can click on. It'll tell you all the different sections. You'll see Rule 4 in there. Click on Rule 4, and it'll give you the different sections of Rule 4. And this is where you need to read. But I'm going to skip on down to the last part, where we talk about, and it's got your sections A through M. And first, before I do that, let me stop at J, because J is the one where we talk. Again, I told you everything's uniform throughout the law, throughout the jurisdictions. This is Federal Rules of Criminal or Civil Procedure, and in here we see 28 U.S.C. 1608 mentioned in Section J. And it specifically says, Section J, serving a foreign, state, or local government. So even if in a civil action you're serving the state or local government, this is what you use. It's telling you specifically a foreign state or its political subdivision, agency, or instrumentality must be served in accordance with 28 U.S.C. 1608. Okay, now if we go back and we look at this, name summons must be name the court and the parties. So when you provide a service upon the state, who are you serving it upon? Who are you supposed to give service to? Secretary of State. He's the one in charge of consular affairs, foreign state affairs. Quit serving it to the court. Serve summons to the court. Serve notice to the Secretary of State. Comprehend this stuff. But again, like I said, that uniform throughout the jurisdictions. It mentions the Foreign Sovereign Immunities Act in the summons here in Federal Rules of Civil Procedure, Rule number 4, Section H, or excuse me, Section J. And so when we go down to M, it says time limit for service. And this is what I was talking to you about. One jurisdiction says 90 days, another jurisdiction says 30 days. So we got to pay attention. And under Rule 4 of the Federal Rules of Civil Procedure for service, it says time limit for service. If a defendant is not served within 90 days after the complaint is filed, the court, on motion or on its own after notice to the plaintiff, must dismiss the action without prejudice against that defendant or order that service be made within a specified time. If a defendant is not served within 90 days after the complaint is filed, the court, on motion or on its own notice or on its own after notice to the plaintiff, must dismiss the action without prejudice against that defendant or order that service be made within a specified time. One more time. If a defendant is not served, remember I've been telling you, they haven't been using the correct service process. They haven't been using the diplomatic channels of notice to a foreign state. So if a defendant is not served, he's not served. Within 90 days after the complaint is filed, the court, on motion or on its own after notice to the plaintiff, must dismiss the action without prejudice against the defendant or order that service be made within a specified time. So, when I signed those tickets, UCC 1-308, I want people to comprehend, I was not served. I was only given an issue of a commercial ticket. I reserved my rights not to consent. Once he gave me that ticket, he then went and made a statement based upon the events of him giving me a ticket. He then filed a summons. Just because he gave me a ticket doesn't mean he gave me proper notice. And then I never appeared. No one ever sent me anything in the mail to appear. It was presumed that I knew I was to appear and then didn't. Why? Because I know my unlimited powers of contract. Let my yea be yea and my nay be nay. If you don't comprehend that I reserved my rights and said, nay, I don't wish to participate in your funny clown suit acts and performances. I'm not here for games and stuff. I'm not here to be instrumentalized and played like an instrument. So then they turned around and they committed fraud. They committed libel. They committed slander by talking to each other and then conferring information upon to each other that they then publish on the public record saying that someone is guilty of these supposed criminal acts in civil venues and assessed fines, fees, and penalties, and they are published as such. You can look that name up, Keith Orland Little, on the public record in Waterloo, Iowa. And that is libel. They have never properly served this for the foreign state of anybody they've named in any of their paperwork. In fact, the defendant they named in their paperwork isn't even a foreign state, but they're trying to address it as if though it belongs to me, and therefore they must address myself in the proper fashion by translating those documents into a language that I comprehend, which is concise English. They haven't even verified what my language is. How can they possibly have given a translation? All these tickets are given to people like Bosnians, Asians, Mexicans. Huh? Are they translating these They make sure to put up translation documents in the medical offices, and they have 12, 14 different categories. But if they don't know what language you speak, shouldn't they be contacting the Bureau of Consular Affairs to find out what your nativity is? So that they know what kind of translation to make? These are questions we need to start asking. They're simple questions that will rebut everything they have to say. Put them on their asses, dumbfound them with logic and rationale. I dare them to try to come after me with them court charges. I've got 11 citations sitting there that I signed UCC 1-308 and then never appeared in their courts because it's not my prerogative, it's theirs. They seek economic substance. I'm not after economic substance. They can try to prove joinder all they want, but any joinder they have has always been authorized representative, wherein any where they seek economic substance in any manner proves that it's a civil contractual nature where I'm, as authorized representative, I'm not liable. The state trustee is. State trustee's liable because he didn't keep his act right and listen to the real people that know what's going on, so that when we did bust this loose, we can sit there and say, fuck you, and all your legislation is no good. We talk about this statutory, state statutes or international law, and we're going to get to that here in a minute because, like I said, it's uniform throughout all jurisdictions. Your state statutes are commercial, your commercial codes, which is the UCC, and it says within it, uniform throughout all jurisdictions, UCC 1-103.3, I believe. Look it up. So when we talk about time limit for service, if defendant is not served within 90 days after the complaint is filed, the court on its own motion or on motion or on its own after notice to plaintiff must dismiss the action without prejudice. That means he's not supposed to assess fines, fees, and penalties. So when he assessed those fines, fees, and penalties, he did so without proper evidence. He doesn't have proof that that foreign state exists. He has proof that a state citizen exists and a federal citizen exists, which is a dual citizen. And this is something I want to point out to you people claiming your nationalities and stuff. I just talked to you about Title 18 of the United States Code, Section 911 and 8 U.S.C. 9, where we talk about, not 9. We talked about the nationality, where in Title 18 of the United States Code 1481, where we talked about nationality in reference to person, and wherein nationality is conferred upon a person. It's not conferred upon a man, it's conferred upon a person. Okay, so when you're claiming this nationality, you're claiming a nationality for a person and thereby still claiming a person under that nationality instead of a person under your own operation of a private association. You're giving a last name according to some kind of heritage. Again, Samuel Clemens created his PMA in a person of his own without a nationality. He created a stateless person in which he operated commerce in and wrote all of his words and writings under and had no liability. He himself was blameless. Comprehend this stuff, people. When you start claiming that nationality, you're claiming somebody else's jurisdiction. Even you Moors, you're claiming somebody else's jurisdiction that they claimed at some point in time that didn't exist eternally. Process of service of notice. So, anyway, must dismiss the action without prejudice against that defendant or order that service be made within a specified time. So again, we have to go back and restart that service thing. We have to find some way to service. Well, they're not willing to serve me through the proper channels and give me something to sign as a receipt, because I'm going to put my signature on there and it's going to be forwarded back to them with a fee schedule. You want to put an offer up there for me to sign? Here's my fee, copyrighted. You want to use this name? Copyrighted. Oh, and let me tell you what, it's established under the Pure Trust, Genesis chapter 1, verse 26 through Genesis chapter 2, verse 25. That's your pure trust, wherein God created man and gave him dominion of the land, air, water, and all the seeds and plants, and told him, go forth and prosper and be abundant, and to use that to his liking so that he could pass it forward. He was to do so judiciously and in love and kindness. That's the trust. That's the pure trust. So anything below that, you want to talk about service? I said in David Jose's video earlier today, when they call out Keith, when they call out to myself, Keith, they have called upon Almighty God. Because I know as long as I follow His way, I am blameless. So when it comes to your commercial entities, and your seeking of economic substance through your statutory codes, rules, regulations, acts, edicts, proclamations, ordinances, and whatnot, that's your word. In beginning was word, and I am law. I am the land, air, and water. I was given dominion over this land, air, and water. I was given dominion over this matter, and I am subject to the spirit of this matter. That's my subject matter. I am guided spiritually, not manually. I am guided by the voice within and not the spoken word written down by somebody else. So, but if the plaintiff shows good cause for the failure, the court must extend the time for service for an appropriate period. What's good cause for the failure? He can't find the defendant? He knows where the defendant is located. It's in the Bureau of Vital Statistics at the Secretary of Office or Secretary of State's office. It's called the Certificate of Live Birth. It's called the Original Statement of Live Birth. It's the original document. They know the origin of their instrumentality. They know where it was first certificated. They know where it was instrumentalized into a financial instrument being conferred as information from a lawful document. They conferred nationality upon a person by taking information, transferring information from a lawful document onto an abstract form, which created a financial instrument known as a person. This subdivision M does not apply to service in a foreign country. Time limit for service does not apply to service in a foreign country. Under Rule 4F, 4H2, or 4J1. Remember, I stopped and we looked at J? 4J1. serving a foreign state or local government. Foreign state. A foreign state or its political subdivision, agency, or instrumentality must be served in accordance with 28 U.S.C. 1608. And when we go to 28 U.S.C. 1608, we see there's a time limit of 30 days in which they must respond. 28 U.S.C. 1608, Part 4 of subsection A says, if service cannot be made within 30 days under paragraph 3 by sending 2 copies of the summons and complaint and a notice of suit, together with a translation of each into the official language of the foreign state by any form of mail requiring a signed receipt. Here's one thing I want to point out to you guys. I came across this a few years back when I first started educating myself in this, and that is Title 31 of the United States Code, Section 1321, subsection, in parenthesis, 73, unparenthesis. Write that down. 31 U.S.C. 1321, parenthesis, 73, unparenthesis. When you put that into your search engine, you're going to come up with a part there we're talking about the estates. And this is all part of the Public Charitable Trust. And you will see this part 70, subsection 73 there says, estates of decedents and trust funds. Now, the Public Charitable Trust is a trust fund, and it doesn't state anywhere any denotion of separation of trust funds. It just says trust funds, and that includes all trust funds then. And the Public Charitable Trust is a trust fund of which the United States citizen is a part of and has a sub-account of. And this means, when we see that, it's telling us under the assignment of Title 31 of the United States Code, the U.S. Department of State has fiduciary assignment of estates of decedents and trust funds. This is why the counselor of foreign estates is supposed to be noticed by proper diplomatic channels if a suit has been filed against a foreign state, because they know who that foreign state is, because we're tied to that birth certificate. They're the fiduciary assignment. So when we give them that information, they're supposed to say, okay, well, this, hand it over to the Department of the Treasury, and Comptroller General assigns tasks to the Comptroller of Currency and the IRS Commissioner to set off the charges. When you comprehend this stuff and know this stuff, that's all you got to do is you assert it in the courts. You don't have to write this shit down. You follow it along. When it comes, like I said, when it comes to these state statutes being commercial contracts, look up Title 48 of the Code of Federal Regulations, Part 52.212-5. And it'll tell you all contract terms and conditions required to implement statutes or executive orders - commercial item. Anything tied to civil actions. In other words, their codes of federal rules of civil procedure, their rules for commencement of civil actions. Those are all contractual terms as well, and they have to be done in a civil venue. You can't take a civil venue into a criminal venue. So even your federal rules of civil procedure have to be held in a civil venue. They have to be contracted. So in order for them to force me to follow federal rules of civil procedure, I have to contract with them. We're going to show you something here. Remember I was talking about uniform throughout all jurisdictions. Where was I at here? Oh, here we go. We go back. Because I want to finish this up first before I go on to my uniform throughout all jurisdictions here. The court may assert, M, does not apply to service in a foreign country under Rule 4F, Rule 4H2, or 4J1. 4J1 is very important. Does not apply to service in a foreign country. Why? Because service in a foreign country has to be done through diplomatic channels of service. Title 22 of the Code of Federal Regulations, Section 93.1 and 93.2. Foreign Sovereign Immunities Acts, Title 28 of the United States Code, Section 1602 through 1611. And now we're going to go to The Hague. The Hague. The Hague. International law. The Hague Service Convention. And when we look at The Hague, we look at Rule 14. Or excuse me, not Rule 14. What is it? I lost my thing here. Oh, here we go. And I posted this in a post just below this video. There's a link to it and everything, so you can go back and read this. But I'm going to read from it what I posted. Here, officially, it's called the Convention of 15, November 1965, on service abroad of judicial and extrajudicial documents in civil and commercial matters. Convention of 15, November 1965, on the service abroad of judicial and extrajudicial documents in civil and commercial matters. So when we see civil and commercial, it means they're both the same. They're basically both the same. Civil and commercial, civil is more commercial, and commercial is more intra-contractual, whereas contracts is international law. And that's why we see statutes being portrayed as state commercial codes, and yet international contract laws. They're uniform throughout the jurisdictions. Civil means commercial, commercial means civil. And we see in our own tax code, it says commerce is synonymous with trade, traffic, transportation. What do we talk about? International trade and commerce? So think about this stuff. Service, international or channels of diplomatic service. And so when we talk about it, it says colloquially, it's called the Hague Service Convention. And if it applies, its structures must be followed in U.S. courts. To be sure, treaty analysis is not a precise analog to statutory construction, but that doesn't mean it is overly complicated. But at the same time, here they're mentioning treaty construction. It does say that that we're talking about treaties. In other words, the United States has a treaty of peace in which it professes that it will operate commercially and contractually with the rest of the world in peace. In other words, in uniformity with what they agree to. Okay? And that's why things have to be uniform intra-jurisdictionally within the federal jurisdictions, within the state jurisdictions, within the county jurisdictions, within the municipal jurisdictions. Everything has to be uniform. So it says, in general, the convention lays out the methods by which a U.S. plaintiff can serve a defendant in another country that is also a member of the treaty. Of the treaty. So what's the treaty? Hague Service Convention. Hague Service Convention is a treaty. It's something important that we need to make mention of in our PMAs. in regards to when these road pirates want to pull us up over alongside the road and ask us for some kind of ID. And real quick here, just so you know, one of the maxims of law, I just want to make a very clear point. One of the maxims of law is the presence of the body cures the error in the name. And so when a road pirate stops you alongside the roadway and he asks you for that driver's license or ID, and you hand him a driver's license or ID, he knows already you're the only one that's supposed to be allowed to have that ID. That's a separate entity from yourself. That right there, possession of that ID, is presence of the body, cures the error in the name. And if you know how to use this, you use it before you even have service. Like I said, I signed them all UCC 1-308. The presence of the body cures the error in the name, and if you want to send it to the person, you're sending it to the person and not myself through proper diplomatic channels, and not giving me the ability to sign a receipt saying one transaction has already been committed to, and now I have been billed, and now I'm signing a receipt for that transaction. You want to get me involved in a series of transactions that I don't know the outcome of, except that I'm going to be assessed as a fine, fee, or penalty? I don't think so. You better give me a receipt for every goddamn transaction. I go to Walmart and I commit a transaction, I get a receipt for it. They can't convince me to go do a whole bunch of shopping and walk out the door and come back at a later date and say, okay, well, you can do some more shopping, but at some point in time, we're going to assess you the shopping fee. It's not how it works, people. So anyway, we go on. It says, very specifically, I want to talk about Article 2 of Rule 14 of the Hague Service Convention. Article 2 says, requires member countries to designate a central authority to field service requests from fellow treaty members. Each state falls under the Hague as treaty members of the International Corporation of the Federal Government. They have to abide, just like constitutions have to abide by the federal constitution. The United States is bound by the Hague Service Convention, and therefore the states are bound by it as well through Title 48 of the Code of Federal Regulations, 52.212-5, wherein all their commercial activity is construed to be contract terms and conditions must or are required to implement statutes or executive orders. Contract terms and conditions required to implement those. So in order for them to implement those statutes against myself, they have to have contract terms and conditions to do so. It has to be a civil matter. It's a must. It's a requirement. Usually this authority is the Foreign Ministry or Justice Ministry, analogous to our state justice departments, or in some cases a specific court. Here in the U.S., our central authority is technically the Department of Justice, but, get this people, its functions are outsourced to a private firm. The functions of the Department of Justice are outsourced to a private firm. The private firm, as you might expect, charges foreign requesters $95 to serve U.S. defendants. Private firm requires or charges foreign requesters $95 to serve U.S. defendants. I'm not the U.S. defendant. They're not serving the right man. Comprehend this stuff, people. They have to serve the representative of the defendant, not the defendant. Article 5 is the most vital part of the treaty. It's the real crux of the whole thing. It requires a central authority to serve either according to its own method or, if appropriate, in a manner requested by the plaintiff. In a manner requested by the plaintiff means that the plaintiff is serving by their method. And we're accepting it. We don't have to accept service by the plaintiff's way of doing it. That's not the way it works. Walmart just does not give you all kinds of products and say, come back on October 29th. And we'll decide then how much we're gonna charge you. It doesn't work that way. It's what these courts are doing. They're saying, "Come on in and we'll talk about it, and we'll get another representative." I don't need somebody to do my grocery shopping for me. This is how ignorant this stuff is. So anyway, we got to start looking at The Hague in regards to this stuff. And in regards to The Hague, I want to go to Section 14, Article 14, Rule 14, third-party practice. And we talk about timing and summons and complaint, third-party defendants' claims and defenses, all this stuff. And this isn't stuff that you're going to need to get involved in heavily, but you need to at least kind of look through it and see where it's uniform throughout the jurisdictions. You can see how a lot of this stuff is common, and they mention the same things. Like I said, it talks about the rule of service according to the United States. So then when we look at the rule of service according to the United States, we see the Foreign Sovereign Immunities Act. When we see the Foreign Sovereign Immunities Act, we're talking about 92.3 or 93.1 and 93.2 of Title 22 of the Code of Federal Regulations. We got to realize what our foreign state really is and how much power we really have in that. We have the right to stand up just by recognizing ourselves. We don't have to recognize ourselves as this or as that. We only have to recognize ourselves as foreign to this or to that. I'm foreign to your national country. What is it about your codes that says that I have to state any kind of nationality? All you have to know is that I'm foreign to your state and your rules don't apply to me. Your rules can't sit there and say that I have to claim my nationality. Your rules only state that you have to take an oath and allegiance to your nationality. You want to claim that dual master, then go ahead. Because a state citizen is a United States citizen, and a United States citizen is a state citizen. A national of one is a national of the both. You're claiming a person in both statuses. You cannot serve two masters, yet you're sitting there claiming two masters while you faithfully go to church on Sunday in your Christian beliefs and pray to God as your one master. Go write another check. go write another check in 2 languages without realizing what either language is, because you don't comprehend either language, even in its basics. Oh, let's not forget the 3rd language called microprint that you can't even see. All legal documents and the instruments are supposed to be confined to 1 language. 1 common language, a 1-to-1 basis. Yet everything in that system uses 2 languages. 2 languages. Every check, even without the microprint, has 2 languages. Every promissory note, even without any microprint, has 2 languages. It has a literal scriptural language where we talk about words. And then it has a literal numerical language where we talk about numbers. What are numbers? Is it the singularity? Is it duality? Or is it an all? Infinite? Is it finite some way where we can define it down, define it to just 1 or to 0? What is 0? Is it half of infinity? 2 zeros connected infinity? Is that 1? 1 0 plus 1 0 equals 2 zeros? I'm confused. See how confusing numbers can be in their most basic? 1-to-1. 1 language. In beginning was word. I'll speak to you man to man. Because even writing it down is a second language. It's a secondary language. This is the whole principle of getting another live man in the same venue and speaking back and forth. 1-to-1. Testify. You've written them down in a libel. Get on that stand and speak them. Slander me. Slander myself face to face. State's already written them down as though I owe them some kind of monetary term. Most of them fools can't even figure out what a monetary term is, let alone what the know what the gold clause is, what the commerce clause is, what the differences are between the two, what the Title 12 of the USC 411 is, and what it means, and the comparison between that and UCC 3-402B 1 means I'm not liable for your fictional construct that has no intrinsic value, yet for everything I put forth in my physical labor extensively throughout my life, you owe me for in a substantial way. Through good faith and fair dealings, full faith and credit. So we have to think about this stuff and realize we have a inherent diplomatic right. Like I said, I'm foreign to you, you're foreign to me, I'm foreign to my father's foreign to me. We have inherent diplomatic rights of notice, and that is a conceptual language to be able to come together in peace. Come to your brother in peace before he drag you before a court. Before he send a summons to a court to drag you before them through a third party. All of this is supposed to be done through that third party. They're not doing it through a third party. They're doing it through themselves and then enforcing it through themselves. It's the state performing an act with the state to enforce the state's acts with the state upon another foreign state because the state says so. Who the fuck is the state? So think about this stuff, people, and comprehend. Everything is uniform throughout the jurisdictions. If you have any questions on it, do your research. My next video, I'm going to do a little bit of research on the Social Security Act. See see if I can show you again a uniformity throughout the jurisdictions in regards to their economic substance. We already showed you that the statutes are implemented by a requirement of contract terms and conditions. And that means anytime they take you to court in any civil matter and they're seeking a fine, fee, or penalty, even though they're describing it as a criminal act, then that shows it's a civil matter. If they're impugning some kind of criminal penalty for a civil act, that's fraud upon the court. That's treason. Period. You can't convey a civil act into a criminal behavior or into a criminal penalty. You can't do that. They have to have specific parity. And so when we're talking about these civil acts being committed against us, and they assess a physical penalty of jail time, then they're committing a tortious act, no matter how you look at it, through a civil venue that can only have civil penalties in a monetary loss or gain. When we seek economic substance, it can only be through a economic loss or gain, through some kind of trade. This is why it's important to comprehend that contracts are done under equal consideration for equal benefit, and if they go awry in any way, both or all parties are supposed to suffer equal detriment. So if the judge is sitting there imputing that you have to serve 90 days, you immediately request that plaintiff, the prosecution, spend 90 days in jail with you, or split it. Tell you what, if you want to profess a 90-day sentence, I'll be glad to split that 90-day sentence, as long as that prosecutor shares my cell with me and the rest of the gang. Come on, let's go tell them some bedtime stories, motherfuckers. I dare you to put me in jail again. I dare you. I'll have your funny ass, clown ass robe sitting in jail with me. Let's talk about some bedtime stories, brother. So, I really want you guys to think about this and be done with it. No more. No more. The word heard around the world. No more. Hey people, if it wasn't for you, I wouldn't be doing this. God bless. Have a great day. Bye.